I was interested in what I would call a relatively soft formulation of the model law about governance. In the Delaware Valley, where I come from, where a lot of CCRCs exist, it's often the case that in their early days, maybe about 30 years ago, the governance of the CCRC was actually in the hands of what you might call resident founders. And gradually the boards evolved away from residents to be wholly non-residents. And since residents, in the case of a not-for-profit CCRC, are the sole source of the money that runs the place, I'm wondering why there should not be resident board members who are elected by residents, rather than, as you described, nominated by the board from among residents on the basis of professional qualifications. Shouldn't there be at least some residents or some board members who are deliberately elected to represent residents' interests?
That's a good question, and from my perspective, I think several of you may have different views, but from my perspective, I've seen a variety of different mechanisms for the establishment of a nomination of personnel to boards. Some boards are run very democratically, that the members of the board are elected by constituents that the board is responsible. In many companies, for example, a board members of the board are elected by the people that own the stock in the company. However, in a lot of those cases, the stockholder really doesn't know the individuals that are nominated very well, and it's to some extent, these are people that are pre-selected, and it's a pro forma type of operation. In other boards that I've been associated with, the nominating committee is given a considerable license to look for people who are have specific qualifications that are useful to the board and useful to the organization which it governs. And I must admit, from my personal experience, I've found if you develop a board that has a broad spectrum of expertise in the disciplines and areas in which the organization works, those boards tend to be more effective in general. But I know many of you have been involved with boards of your own, and you may differ from me from my opinion.
I'd just like to amplify that. I agree thoroughly with what you're saying of the need for diversity on the board. But in terms of a resident from the CCRC, that is a particular perspective that is important to the CCRC and does not come from this diversity that you're talking about. So that the idea of an elected member who is a resident of the CCRC has a very specific, separate role to play, and I'm disappointed that that isn't reflected in the statement that you have on governance.
Let me go to Jack.
Yeah, I'd just like to defend this a little bit, because I may have had something to do with this first. So maybe I better.
Gee, you're such a nice guy otherwise.
Well, that's easy for you to say.
A board is a creature of law, found by law. Under the common law,
Use the mic.
under the common law, the board has certain prescribed duties. The loyalty must be to the enterprise. A board is not a representative body. I think we see in the Congress of the United States what's happened sometimes if you get into a representative kind of context. A board has a duty of care, to be diligent in ensuring that the enterprise is managed on a fiscally sound and responsible basis, a duty of loyalty to the institution as a whole, and not to anybody who may have elected them to represent them. It's not representative. The duty of loyalty is to the institution as a whole. So if residents were to represent solely resident interests to the exclusion of the whole, they would have personal liability, could be sued and held accountable for that dereliction of their duty. The board has a duty of obedience to the collective decisions of the board. It's expected to be a collegial, deliberative body. It's not a divisive, partisan body. By law, it's required to be deliberative and to address the overall interests. And it has a duty of confidentiality, to keep confidential matters confined within the boardroom. And those responsibilities are quite different in a body like the Congress of the United States, which is intended to be a representative body. And I suppose you could supersede the common law by statute, but the common law practice for corporate enterprises has worked rather well and has served the public interest quite well. Then I might add that the sanctions for excluding, I mean, there are some executives and there are some CCRCs, unfortunately, which are tolerated by the industry. And that's what's unfortunate. The industry has not policed its own kind, who exploit the people in their care and who discriminate against those people solely because they were unwise enough to accept residency. This law includes a very strong sanction. Under insurance, when the management proves incapable of governing the organization, the insurance commissioner can take over the governance, run the enterprise, usually they bring in a special master or an expert, until such time as the governance is corrected. This provides the same thing, that if it's found by the regulator that the provider is discriminating against residents, which is what is now the case frequently. They will say residents can't be trusted to vote for increases, but executives can be trusted to vote for compensation increases, which is a curious distinction which shows who exercises the ownership. In that case, then, they would be put under notice to correct the deficiency in their governance, and if they don't do so in a reasonable time, then they would forfeit the right to govern themselves until such time as they corrected the deficiency in the governance. I think that's a reasonable approach. But to undermine the whole basis of corporate law in the United States, to make it something like where a Woolworth store, to take an example which is historic, would be governed by so many of the customers could vote for X number of the board members, would be a little bit silly.
May I respond to part of what you're saying? Part of what you're saying is the same argument that we're getting from management, that there is a conflict of interest of having a resident on the board.
Well, they have a conflict of interest too.
Let me start by saying, which is baloney.
Well, I agree.
The resident certainly has an interest in the well-being of the community, and if it is required to increase resident costs, that has to be something that they vote for. So I just don't buy that at all, and I don't think most of the residents do.
Well, I think you think you're arguing with me and you're really agreeing, so.
Before we go to that question,
Let me
give
have
some
a
personal
follow-up.
views.
Well, in order to have a coherent conversation, let's follow up on this particular issue. I agree with our friend in front.
Okay.
Let me just say a few things in response to Jack. On the one hand, there's the theory of law. I mean, laws say corporations are people. I mean, there are a lot of theories in law which really don't hold water. So I'm not sure that the argument from law is persuasive. What I'm dealing with is experience. And the experience is that if you have a board of directors of a CCRC, some of whom are lawyers, some of whom are accountants, some of whom are health professionals, all of whom come from off campus, from the surrounding communities, none of whom are residents. They get all their information via information provided by the management, which has no skin in the game. There are no residents in the thing. They just simply are not qualified to understand the situation as perceived by residents. And the second thing is what my friend has said in the front. It's true the board has a responsibility to the well-being of the enterprise, but in a not-for-profit CCRC, where the whole enterprise is supported by the fees of residents, there is simply a congruence between the well-being of the residents and the well-being of the corporation. So I don't think there's this schizophrenia that people seem to feel there exists. So I don't really see any reason why a governing board of a CCRC, at least a not-for-profit CCRC, why it should not include at least some residents who are elected solely to represent residents. It just doesn't make logic to me.
But our own law does not exclude residents from a board. It just says it does not mandate it. And I'd like to explain a little bit about my personal experiences. I've been on boards of 2 CCRCs. The first one I was on, they had a rule that you could not be on a board if you were a resident. And I went so far as to say that if a board member entered the CCRC, that was an automatic resignation from the board. However, a number of those members of the board did have relatives, parents primarily, who were resident in the CCRC. So they did have an interest for the residents. When I went to the second one, the second CCRC, the one where I'm at now, essentially the same situation existed. There were no residents on the board, and residents were not essentially excluded from the board for the reasons you have suggested. I happened to look up the law at that time and found that the IRS regulations state that the conflict of interest only applies if an individual is running a business and that business has a contract with the CCRC. That's the only case, the only situation in which a conflict of interest exists under law. It's not even under law, it's under regulation from the IRS. I had some discussions with our CEO about it. Eventually, over time, the president of our residents association was given a non-voting seat position on the board. This was eventually changed after a couple of years to a voting position on the board. And more recently, the nominating committee of the board has agreed that there will be one resident on the board. That resident is usually, the name of that resident is usually nominated to the nominating committee by I will say, conversation that goes on between residents and the CEO. And I've been a party to those conversations. Marlene has been a party to those conversations. We've both been on that board. The conversations look for someone who has a stature in the community and is also someone who is far-thinking, the kind of a person that will look at the big picture and not necessarily want to immediately represent the residents. That resident representation responsibility lies with our Residents Association president and his position on the board. And that's where we stand today. So we've been able to get there. We did it through negotiation, essentially. John.
A little bit of John Knox history, and it's going to be sort of, I don't think this is as black and white as suggested. It happens for the last 40 years. The residents of John Knox Village, or a committee of the Residents Council, submits 3 names to the board of directors. We're standalone, not-for-profit. And that their nominating committee interviews all 2 or 3 people usually and selects one. So we have 3 residents on a 15-member board of directors. They serve 3-year terms, so they rotate a lot. However, they are full voting members of the board. However, and this is where I'm agreeing with John, he is correct, or excuse me, these 2 gentlemen, they bring a special expertise because they're residents of John Knox Village. They're more sensitive to what the residents prefer, don't prefer, etc. I happen to think the model law should mandate that there should be either a number or a percentage of board members on the board. However, they have a fiduciary relationship like any other board member. And if something comes up which benefits John Knox Village, even if the residents don't like it, that resident board member has to think about the best thing for John Knox Village, which takes into account the residents, but not sole discretion. So they've got to recognize there is a legal fiduciary relationship. So they can't just represent the residents, but they do bring a special expertise, which is why I think the law, as we've written it, should say there should be a resident, at least one or some number percentage of residents on a board of directors.
Okay. I think we've heard you. We may want to change that model law.
I've served 6 years on Seabury's board. There are 2 resident directors on that board. The way they get there, it starts with the nominating committee that's part of the residence council. The nominating committee makes its recommendation to the council. The membership of the council, the community, then votes. Then they make their recommendation to the Church Home of Hartford general membership. And they are the ones that vote the resident director to the board. During those 6 years, sure, I was there to represent the residents' point of view on various issues. But at the end of the day, as a board member, I was responsible to the Church Home of Hartford. And I was sworn to confidentiality on what went on the board. So that's the way it works. It works very well, and I agree with John and Jack Cumming. They've expressed it excellently, and I think it works very well that way.
Thank you very much.
Thank you.